Hello students, my name is Abhishek Sudhir. Welcome to EPG Pathshala. Today we'll be looking at Module 11, Right to Life under the Constitution of India, Part 1, which forms a part of paper number 4, Civil and Political Rights. Much of the development of the right to life under the Constitution of India is down to the creative brilliance of the Supreme Court of India. In this module, we will be focusing on Article 21 of the Constitution of India. Through a series of activist decisions, the Supreme Court has expanded the right to life. They've expanded it in a manner whereby the right to life now encompasses within its ambit and scope the right to a life with dignity, the right to one's own reputation, the right to a clean environment, the right to shelter, and protection from sexual harassment at the workplace. This module will give the students an overview of how and why the Supreme Court has expanded the meaning of the right to life. The learning outcomes of this module. There are primarily two learning outcomes. The first is to give the students an overview of the constitutionally recognized components of an individual's right to life. The second learning outcome is to help the students understand the manner in which the scope of the right to life has been expanded by judicial interpretation. Now, let's look at the text of Article 21 of the Constitution of India. Article 21 states, "No person shall be deprived of his life or personal liberty except according to procedure established by law." For much of the rest of the module, we will focus on the word life only in Article 21. No person shall be deprived of his life. What does that mean? According to Justice P.N. Bhagwati, one of the greatest Supreme Court judges, Article 21 embodies a constitutional value of supreme importance in a democratic society. Justice Krishna Iyer has characterized Article 21 as the procedural Magna Carta of the Constitution. He said so in the famous case of Francis Corelli, which we will be discussing later on. The term life mentioned in Article 21 has been given a broad meaning to include the quality of life. Notice how they draw a distinction between the right to life and the right to quality of life. The right to life simply might mean, in a strict textual interpretation, the right to survive, the right to just wake up in the morning, or the right to just breathe the air around you. However, the Supreme Court, given its activist approach, has expanded the meaning to bring within its ambit the quality and standard of life. In the case of Kharak Singh versus State of Uttar Pradesh, the Supreme Court quoted with approval the judgment of Justice Field in the case of Munn v. Illinois. In Munn v. Illinois, Justice Field said, by the term life, as here used, something more is meant than mere animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. The provision equally prohibits the mutilation of the body by amputation of an arm or leg, or the pulling out of an eye, or the destruction of any other organ of the body through which the soul communicates with the outer world. This principle, this wide interpretation given to the right to life, was at play in the landmark case of Sunil Batra versus Delhi administration. It is in this case that the Supreme Court devised the remedy of a PIL, a public interest litigation. In the case of Sunil Batra, the Supreme Court reiterated with approval the observations of Justice Field, and held that the right to life included the right to lead a healthy life, so as to enjoy all faculties of the human body in their prime conditions. Therefore, not only do you have the right to life, you have the right to a healthy life. Because what is life without health? The right to life, according to the Supreme Court, even includes the right to protection of a person's tradition, culture, heritage, and all that gives meaning to a human being's life. What the Supreme Court is trying to say here is that your right to life includes the right to follow your own customs, to marry however you choose to marry, to raise your children however you choose to raise your children, but at the same time, those children also have the freedom not to be raised in a manner that you wish to raise them in. Each individual, by virtue of being a human being, has the right to his own tradition, his own culture, his own freedom of thought, heritage, and all that gives meaning to his or her life. The right to life, according to the Supreme Court, also includes the right to live in peace, the right to be left alone, the right to sleep in peace, and the right to repose and health. Now let's come to the case of Ratnam versus Union of India. In that case, the Supreme Court defined life as follows: the right to live with human dignity, and the same does not connote continued drudgery. The right to life takes within its fold some of the finer graces of civilization, which makes life worth living, and that the expanded concept of life would mean the tradition, culture, and heritage of the person concerned. Now, let's come to the components of the right to life under Article 21 of the Constitution of India. The Supreme Court has held that the right to life with human dignity, the right to live with dignity, is at the core of Article 21. They say that the right to life is not confined to mere physical existence, but includes within its ambit a human being's dignity. In the landmark case of Francis Corley versus Union Territory of Delhi, the Supreme Court struck down Section 3 of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. In that case, they held that the Section 3 of the Act violated Article 14 and 21. The impugned section, essentially the section that was struck down, provided that a detainee could meet with his legal advisor only once a month, that too in the presence of a customs officer, and only after obtaining prior permission from the district magistrate. It is a cardinal rule that any individual has the right to a fair trial, and when the detainee was prohibited from meeting his legal advisor regularly and was allowed to meet him only once a month, and that too in the presence of customs officer, it was found that this was a direct violation of his right to life. In People's Union for Democratic Rights versus Union of India, the Supreme Court held that non-payment of minimum wages to the workers employed in various Asiad projects in Delhi was a denial to them of their right to live with basic human dignity. This case concerned the construction of the Games Village in Delhi for the 1984 Asian Games. And in that case, the People's Union for Democratic Rights petitioned the Union of India and demanded that these workers be paid their wages, and the Supreme Court agreed with the petitioners and held that non-payment of wages, minimum wages, that would be a violation of the right to life under Article 21. Justice Bhagwati, speaking for the majority of the judges in that case, held that the rights and benefits conferred on the workmen employed by a contractor under various labor laws were clearly intended to ensure the basic human dignity to workmen, and if they were deprived of any of these rights and benefits, that would be a clear violation of Article 21. Now let's come to the fascinating case of Vishaka. In the Vishaka case, the Supreme Court laid down guidelines that essentially prohibited sexual harassment at the workplace. Under Article 141 of the Constitution, the Supreme Court has the power to declare the law of the land. At the time of the Vishaka judgment, sexual harassment was not governed by any of India's laws. The Supreme Court, through an innovative interpretation of Article 21, has ensured that female workers are not sexually harassed by male co-workers at their places of work. According to the Supreme Court, sexual violence, apart from being a dehumanizing act, is an unlawful intrusion on the right of privacy and the sanctity of a female. In Vishaka, the Supreme Court declared that sexual harassment of women at their workplace amounted to a violation of the rights of gender equality and the right to life and liberty, and this constituted a clear violation of Article 21. The Supreme Court set out a set of rules known as the Vishaka Guidelines, as I've already said, governing sexual harassment in the workplace. It is a matter of some satisfaction now that the Sexual Harassment in the Workplace Act has been passed by the Parliament, and sexual harassment has also been made a criminal offence under the Indian Penal Code, especially in the wake of the Nirbhaya Delhi gang rape case. Now, let's come to the rather tricky issue of the right to livelihood. A fundamental question that the Supreme Court of India has to grapple with is whether the right to life under Article 21 includes the right to livelihood. Does it include essentially the right to work? Does the state have a duty to employ each and every citizen of this country if he or she does not have any means of employment? In the year 1960, the Supreme Court ruled that the right to livelihood was not included under the expression life in Article 21. However, this view changed. The Supreme Court through the decades has become more and more activist, and the word life has now been given, as I've already explained previously, a very wide meaning. At this point, it might be of some interest to you to note that the Supreme Court was actually a very minimalist court in the first 10 years or so of its existence. At that point, it would appear that the Supreme Court placed ultimate faith at the end of the day in Parliament, the representatives of the people, and restricted itself to an interpretation of the law. The Supreme Court did not dabble in lawmaking, unlike the Supreme Court of today. Now, one might agree or disagree on that approach, but what is beyond any doubt is that the Supreme Court has had some positive impact. Take the wide interpretation that they've given to the word life in Article 21 as an example, which we are discussing in this module. The framers of the Constitution did not envisage this word life being expanded to include things such as the right to a clean environment or noise pollution. But the Supreme Court has shown some foresight and has, in fact, rather unfortunately for those who believe that a democracy should not be run by the judiciary, essentially, that they have had to step into the shoes of Parliament and they have had to guarantee things like the right to a livelihood, the right to a clean environment, because the state has failed. Initially, the word life in Article 21 was meant to be restricted to only the criminal context. Things like the death sentence, things like sending people to prison by the use of arbitrary laws. However, the Supreme Court has used this word life essentially to arrogate to itself power that the framers never wanted to give it. Whether that is a good or a bad thing is a matter for debate. But it is now beyond any doubt that the word life in Article 21 is the heart and soul of the Constitution, as was seen in the landmark case of Olga Tellez. In the famous case of Olga Tellez versus Bombay Municipal Corporation, popularly known as the pavement dwellers case, a 5-judge bench of the court ruled that the word life in Article 21 includes the right to livelihood also. The court said it does not mean merely that life cannot be extinguished or taken away, as for example the imposition and execution of death sentence, except according to procedure established by law. Let me explain. Let's take the example of an individual who is poor, who lives below the poverty line. Can the state be said to be depriving him of his right to life? One would think that since there is a right to a quality of life, a standard of life, it is incumbent upon the state to give this citizen adequate means of livelihood. The Supreme Court would agree. However, the Supreme Court does not believe that the right to livelihood would mean giving that person a job and employing that person. Essentially, it is incumbent upon the state to give that individual some of the basic necessities of human life: food, perhaps clothing, and certainly shelter. Essentially, this is their interpretation of the right to life. They simply want to say that a person who is poor, who is indigent, cannot be deprived of his right to life, only in the case that he is killed, for example. So an individual might say that he has absolutely no means of livelihood, that he has no food, no water, no shelter. The state cannot respond by saying, well, we are not depriving you of your right to life because you are alive. The Supreme Court disagrees. The Supreme Court says it is incumbent upon the state to ensure that each of its citizens has a decent avenue, a decent means of livelihood, essentially get some of the basic necessities of human life that ensure that he or she is given a life that goes beyond mere animal existence. That is but one aspect of the right to life. An equally important facet of the right to life, said the Supreme Court, is the right to livelihood, because no person can live without the means of livelihood. The court went on in the case of Olga Tellez to state that, I quote, if the right to livelihood is not treated as a part and parcel of the constitutional right to life, the easiest way of depriving a person of his right to life would be to deprive him of his means of livelihood to the point of abrogation. Essentially, the Supreme Court here is looking, or rather taking, a consequentialist approach. What they're saying is if a citizen is denied adequate means of livelihood, it essentially means he is being deprived of his life. Perhaps not by an overt positive act by the state, but by the state neglecting its duty to take care of the citizens and provide them food, clothing, and shelter. The consequence of their actions essentially is that the citizens are being deprived of their right to a life and livelihood. As the Supreme Court said, and I quote, the state may not by affirmative action be compelled to provide adequate means of livelihood or work to the citizens. Now, this is interesting. The Supreme Court says that there is the right to livelihood, but say there is no positive duty on them to provide adequate means of livelihood. This is at best confusing. Let us see what the Supreme Court has to say and how they explain this statement. They say, and I quote, but any person who is deprived of his right to livelihood, except according to just and fair procedure established by law, can challenge the deprivation as offending the right to life conferred in Article 21. Essentially, what the Supreme Court is saying is if the state takes an action whereby an individual is not able to work, is not able to carry on business or employment, and the state does so without adhering to the procedure that has been established by the law, then there is a deprivation of the right to life. Simply, an individual being unemployed cannot claim that by virtue of him being unemployed, the state is depriving him of his right to life. The state must have taken some overt action, essentially, to ensure that he is unemployed. And if he is unemployed, and the reason he is unemployed is because of the state can still rely on the justification that the deprivation of this person's right to livelihood was carried out, was done according to a just and fair procedure established by the law. So let us take the example of a civil servant who is accused of corruption. The government might essentially terminate that civil servant's appointment, and essentially that civil servant would lose his job. In that scenario, they would be terminating his appointment according to a just and fair procedure established by the law, because he has been held guilty, let us say, of corruption either in a criminal trial, or he has been found to be guilty of corruption in administrative or civil proceedings. Essentially, there the procedure has been followed. The individual has been given a fair hearing. It has found that he has essentially been convicted of corruption. He has been guilty of corruption. Therefore, he loses his job. So that deprivation of the right to livelihood is justified because it's according to the fair procedure established by law. That is essentially what the case of Olga Tellez was trying to emphasize. The fine distinction at play becomes very apparent once you look at the Hawkers case. In Shodhan Singh versus New Delhi Municipal Committee, the five-judge bench of the Supreme Court held that the right to carry on trade or business is not included in the concept of life and personal liberty. The petitioners in that case were hawkers doing business off the pavement roads in Delhi. They claimed that the refusal by the municipal authorities to let them carry on their business amounted to a violation of their right under Article 21 of the Constitution. The court opined that while hawkers have a fundamental right under Article 19(1)(g) of the Constitution, which deals with the right to freedom, to carry on trade or business of their choice, they have no right to carry on that business in a particular place. They cannot be permitted to carry on their trade on every road in the city if the road is not wide enough to be conveniently accommodating the traffic on it. No hawking may be permitted at all, or may be permitted once a week. That would be at the discretion of the municipal committee. The Hawkers case essentially said that footpaths, streets or roads are public property and are intended to serve the general public and are not meant for private use. However, in the Hawkers case, the Supreme Court said that the affected persons could apply for relocation and the concerned authorities were to consider the representation and pass orders thereon. Now let's come to the interesting case of HIV and the right to life. In the Bombay Indian inhabitants case, the Supreme Court held that a person who tested positive for HIV could not be rendered medically unfit solely on the ground of being HIV positive. This was a landmark judgment. even though the petitioner might have been a nuisance to others and conducted themselves either in a disorderly way or unbecoming of their profession. That in of it and of itself is not sufficient for the executive to take away their source of livelihood by an executive fiat. So essentially, what the Supreme Court is trying to say is that just because somebody is being disorderly or is being a nuisance, you cannot automatically just terminate their employment. There is a due process, a procedure that needs to be followed, a procedure that is established by law, a procedure, even if established by law, that needs to be just, fair, and reasonable. Now, it's also worth noting and it's worth stating emphatically that the right to work has yet not been recognized as a fundamental right. No citizen of this country has the right to employment or the right to a job. Now, you might ask, if he does not have the right to employment or the right to work, how then does he have the right to a livelihood? Isn't a job the source, the means to get an adequate livelihood? Well, the Supreme Court disagrees. In Shanti Builders versus Narayan Khemlal Thotame, the Supreme Court held that the right to life in any civilized society would include within its sweep the right to food, the right to clothing, and reasonable accommodation to live in. Once again, you need to ask yourself the question, if there is no right to work, how is one supposed to eat? The right to food. How is one supposed to buy clothes? The right to clothing. How is an individual entitled to the right to shelter, reasonable accommodation to live in? It's stated in the case of UP Avas Vikas Parishad versus Fens Cooperative Housing Society Limited that the right to shelter is a fundamental right which springs from the right to residence secured in Article 19(1)(e) and the right to life guaranteed under Article 21. So the Supreme Court has emphatically stated that the right to shelter is a fundamental right. This is interesting. Let us take the case of winters in the north of India, especially in a place like Delhi. The right to shelter has essentially meant that there is a positive obligation on the state to ensure that individuals are not forced to sleep out in the open during the winter season. In the case of Chameli Singh versus Uttar Pradesh, the Supreme Court emphasized once again the importance of the right to shelter as one of the basic human rights designed to ensure all facilities to human beings to develop themselves as members of a civilized society. Now let's come to the landmark case of MC Mehta versus Union of India. The entire jurisprudence of environmental law in India has grown out of a wide, expansive interpretation of the word life in Article 21. In the MC Mehta versus Union of India case, the Supreme Court ordered the closure of several tanneries, leather tanneries, that were causing water pollution. The Supreme Court also issued guidelines and directions for the protection of the Taj Mahal, an ancient monument, from environmental degradation. The court also held that blatant and large-scale misuse of residential premises for commercial use in Delhi violated the individual's right to a salubrious and decent environment. So essentially, the court has gone to the extent of saying that commercializing a residential properties in Delhi violates the right to a clean environment and ergo violates the right to life. Therefore, the right to life includes the right to breathe clean air. In the famous case of Milkman Colony Samiti versus State of Rajasthan, the court held that the right to life means clean surroundings which lead to a healthy body and mind. The Supreme Court upheld also the right to freedom from stray cattle and animals in urban areas. But many of you who live in urban centers in India find that this is still a utopian dream, as there is still no freedom from cattle and animals in urban areas. Now let's come to the interesting case of smoking. Do you have the right not to be subjected to passive smoking? As many of you might know, passive smoking essentially means an individual inhaling smoke that is exhaled by another individual. In the case of Murli S. Theora versus Union of India, filed where the petitioner was the former Union Minister Murli Theora, the court held that persons not indulging in smoking cannot be compelled to or be subjected to passive smoking on account of an act of a smoker. It is for this very reason, it is because of this very case that there is now a general ban on smoking in all public areas in all of India's major urban centers. There is also a ban, you might notice, in restaurants. For example, in any closed restaurant, smoking is banned where there is air conditioning. Certain restaurants do have smoking areas. Certain airports have smoking areas. Also, certain train stations have certain smoking areas. Therefore, all of this is a result of the Murli Deora case, where the Supreme Court held that passive smoking, being compelled to inhale smoke that is exhaled by somebody else, amounts to a direct violation of the right to life if the state does not take steps to ensure that there is a smoking ban or there are smoking zones. Thus, the right to life under Article 21 is affected as a non-smoker may become a victim of someone smoking in a public place. Now, let's come to noise pollution. Noise pollution has been dealt under the purview of Article 21 by the Supreme Court in re noise pollution case. The court held that nobody can claim a fundamental right to create noise by amplifying the sound of his speech with the help of loudspeakers. The Supreme Court held that while one has a right to speech, others have a right to listen or to decline to listen. If anyone increases the volume of speech, and that too with the assistance of artificial devices such as loudspeakers and amplifiers, so as to compulsorily expose unwilling persons to hear a noise raised to unpleasant or obnoxious levels, then rights of others to a peaceful, comfortable and pollution-free life guaranteed under Article 21 is being violated. There you can see that the Supreme Court has not only included the right to a clean environment, but has gone to the extent of bringing in noise pollution as well within the ambit of the right to life under Article 21. So students, we now come to the end of this module. This module has demonstrated how the Supreme Court, for better or for worse, has taken it upon itself to give the right to life a wider meaning than was originally intended. The Supreme Court's right to life jurisprudence has now meant that the state has to guarantee citizens shelter, a living wage, a clean environment, and above all, a life with dignity. The Supreme Court has sought to emphasize that the right to life does not mean the right to a mere animal existence. It means the right to a quality of life, the right to a life that ensures that the basic necessities of life are given to a particular individual, like food, shelter, and clothing. Now, the question might arise that should the Supreme Court impose such obligations on the state? Well, irrespective of whether one agrees or not with the activist approach of the Supreme Court, one cannot help but admire their judicial craftsmanship. The onus is now on the state to live up to its constitutional promise. The time has now come for the state to redeem its constitutional promise of giving its citizens the right to life with dignity, a right to a life with the adequate means of livelihood. Whether they do so or not still remains to be seen. But the Supreme Court has certainly done its part in enumerating, expanding, and defining the scope of the right to life under the Constitution of India.